Assalamualaikum everyone. I think it's 3:05, so let's get started. We have our speaker ready. So let me start with Quran recitation. أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. والعصر إن الإنسان لفي خسر إلا الذين آمنوا وعملوا الصالحات وتواصوا بالحق وتواصوا بالصبر. صدق الله العظيم. Assalamu alaikum, brothers and sisters. On behalf of the KMCA board, I would like to welcome all of you, especially our guest speaker, Brother Ahmed Shaikh, to today's virtual session on Islamic wills and living trust. I hope that this session will benefit our community to learn more about Islamic inheritance and Islamic estate planning, which is an obligation on us to our families. And inshallah, it will help us to fulfill these obligations. Today, our guest speaker is Brother Ahmed Shaikh, who is an attorney based out of South California. He's a certified specialist in estate planning, trust, and probate law, and he has been an attorney for more than 20 years. Also, Brother Ahmed Shaikh has given lectures at many national Islamic conventions and also at many Islamic centers throughout the country. And he has been conducting workshops on Islamic inheritance in Bay Area masjids like MCA, MCC for many years. And also he maintains a very useful blog at islamicinheritance.com. So before we begin the main session, since this is a virtual session, I request everyone to mute your microphones during the main session. And we can use the chat window for any communication during the main session, and inshallah we'll have a Q&A towards the end. And maybe for the Q&A we can use the raise hand option if it's possible in Zoom, so that I can just call out your name and you can ask questions and take turns instead of to avoid cross talks. Also, we are recording the session so that we can use it for future reference, inshallah. All right, without further delay, let me welcome Brother Ahmed Shaikh to start the session for today.
Assalamu alaikum. It's a pleasure being here and virtually meeting with everyone. I'm going to try to figure out, this is actually the first time I've done one of these things on Zoom, and I'm going to try to figure out how I can share my screen and actually specifically share a keynote. So I'm going to be doing that right now. Just give me a moment. Here, I think I got it. Okay. So this is what I'm going to be talking about. Is primarily going to be about about us as our obligation to make sure that we take care of the people that we love and that we care about. Fundamentally, what we do when we do estate planning is that we have this recognition and this realization that that we live in this world, and we're not going to always be in this world. We are going to leave behind people, assets, and that there is this obligation that we have under the Islamic rules of inheritance. We have an obligation to each other. We have an obligation to our society. So that's what we're going to be. That's what we're going to be talking about. Of course, I do realize that the group that I'm speaking to primarily is there's going to be a lot of people who are non-citizens, and not only non-citizens but non-residents as well. There are a lot of people, and I know that this is the case in particular in the Silicon Valley, but this is certainly the case in other parts of the country, including Southern California. I know that this is a much bigger issue in the Silicon Valley than in other parts of the country, where you have a lot of people who have family outside of the United States, and not only that, you have very close family outside of the United States. You're often here in the United States because of employment opportunities, and that actually creates some special problems. So we'll talk about that. Okay, a little bit about myself. Let me see. Let me try to get this. Let me see if this works. Okay. So this is me. I am and Jazakallah khair for the kind introduction. I am a board certified specialist in estate planning, trust, and probate law. I'm the former chair of the Orange County Bar Association. Another thing that I did was Orange County Bar Association Trust and Estate section. I'm also the author of a book called Estate Planning for the Muslim Client that should be here, but it's not. There's a copy there as far as picture of that goes. I'm the co-author of a book. It's a practice guide on making sure that people who want to practice based on their values, specifically Muslims who want to be able to do their estate planning based on their values, are able to do so. And there's a lot of different steps that go into that process. Now, before we do that, I want to be able to talk about what the system is for inheritance in the United States. And that's going to be pertinent for you, especially if you're going to have property, you're going to have bank accounts here, you're going to have a house here. If you're going to have any of these types of assets here in the United States, you're going to have to contend with what the system is in the United States. The first thing you need to be able to understand about it is that we have this system of what's referred to as testamentary freedom. What's more is that we have this system of free alienation of property. So free alienation of property is this concept that it's my money, my money, my money. I can do with it as I please. So if you want to, you want to give your money to one person, more than one person, you don't want to give it to anyone. You want to give it to all the charity. You don't want to give it to charity. You want it to be put up in a gigantic pile and you want it burned in front of a group of orphans. You can do that with your money because it's your money and this is America. And because it's America, you can do whatever it is that you want with your money. And so that's basically the system. Now, it's maybe somewhat of an oversimplification. There's going to be certain obligations that might exist in certain states. There's, of course, what property it is that you own. We need to be able to establish what that is. And that's one of the things we're going to be talking about as well. As far as some of the items that I do want to discuss with you is, of course, I did notice that there were a number of questions that came about before, and that actually is guiding some of the discussion that we're going to be having today. I'm going to be talking about guardianship for minors. So many of you have minor children, how that would actually work, particularly in an environment where you don't have any family members that are close by. And we're gonna talk about the property system. Community property, for example, is an important concept that we're going to be discussing, and we're going to be talking about how to actually implement all of this so that you're making sure that your loved ones are taken care of appropriately. Now, this is of course the Quran. This is Ayatul Kursi, right? And so everybody is familiar with Ayatul Kursi. One of the things that one of the things that's in Ayatul Kursi that actually exists elsewhere in the Quran, lahu ma fis samawati wa ma fil ard, right? Everything in the heavens and the earth and all that it contains belongs to Allah. And so this is actually a major difference between the concept of free alienation of property and the concept of property ownership in the United States, right? Because everything that we have, all of our possessions, our house, our bank accounts, all of the stuff that we have, all that stuff that we have that we're not going to be able to take with us, all of that is entrusted to us. All of that, everything in the heavens and the earth and everything in it, all of that, including our own bodies and everything belongs to Allah, right? And so everything is entrusted to Allah, and whatever you're doing something that is haram, right? If you're doing something that violates that trust, you're violating the trust that Allah has placed in you. And so what we know about our wealth is that we have this thing called zakat, right? So we have to make sure that if we have some wealth, we have to pay in charity. We have to pay in charity because it's actually not ours. A certain amount, there is a right that belongs to others. The poor, for example, they have a right over our wealth. And so what the Quran is also telling us elsewhere in the Quran is that not only do the poor have a right over our wealth, but our family has a right over our wealth as well. And so let me just talk a little bit about what can go wrong. And so this is a glass slipper. And so the significance of that might be apparent to some people. But there's this, I don't know if you've ever been down here to Southern California. If all of you have been here, and there's this there's this place called Disneyland, and there's this, the story comes up over there, and there's a movie about it. But basically, it's this story that starts with a man and a woman, and this man and a woman are married, right? And they are married, and they have this daughter together, and they are living very happily, wonderfully. Everything is going really well, except unfortunately, as stories like this go, the mom of this young daughter, of this young girl, passes away. So the mom passes away. What happens? What happens is that the man will get remarried. One of the things to understand about this is that this is a very frequent occurrence. We actually have this adage in estate planning, and it's not just from estate planning. It's been around since at least the 70s, where I think it came from a poet once, that women mourn, men replace. And men will frequently get remarried, and they're not going to be especially picky a lot of the times. They're going to marry very, very quickly once they have lost their wife. And this is just something that we've seen over and over and over again. And it causes an immense amount of fitna in families. And a lot of the work that we do in estate planning and estate administration and estate litigation has to do with what kinds of problems are come about when one spouse passes away and the survivor gets remarried. And so what happens in this particular story is that the man gets married to a woman who has two daughters that are about the same age as his own daughter. And they're doing fine. They're doing just fine. But then what happens is this man, the father of this little girl, he passes away after that. And then the the wife, the stepmom of this young girl, then takes the wealth of this orphan and weaponizes this orphan's wealth against her. And this is the story, of course, of Cinderella. And that story of Cinderella, as we know it, didn't necessarily just come from Europe, and didn't necessarily come from Disney or the Grimm brothers or any of that stuff. This story is actually quite universal. Literary scholars have found that this story of Cinderella, has existed in virtually every single language and culture throughout all of recorded history, all written history going back thousands of years in Vietnam, China, or the Middle East, or anywhere else where people have written words about stories. This particular story of the weapon's wealth being weaponized against her or him actually exists. And so this is something that happens quite frequently, even to this day, where orphans are not orphans, and the wealth of orphans is taken away from them, and the wealth of orphans might even be weaponized against them. And so a lot of times people don't necessarily think in terms of, well, who the villain is in Cinderella. Cinderella, the real villain, might not be the wicked stepmother or the wicked stepsisters. The real villain might be the birth mother and the birth father, who didn't think to concern themselves with what might happen in the event that one or both of them passed away. And so one of the things you want to do is consider consider that you are working towards justice, not justice, some amorphous justice somewhere out in the world, or something bad that's happening to one person or another. But remember, you are going to consider planning for a world in which you are not going to be a part. You are not going to be a part of this world, and the circumstances of the people that you leave behind, you are utterly ignorant. This is what we refer to as ilmul ghaib, right? You don't know what is going to happen. And so what we have is a system that addresses, a uniform system of, of inheritance that addresses that, which I'm going to discuss. Another concept I want you to be very familiar with is joint tenancy. The most common way that joint tenancy will come about is when we own a home together with a spouse. So a husband and a wife own a home together. They might do this with a bank account. They might do this with a brokerage account. They might do this with any number of assets. But joint tenancy with right of survivorship tends to be the default way people own their homes. And so what you're going to be doing when you own a home is saying, well, if I die, my wife will get everything. Or if my wife dies, I will get everything. One thing to understand about joint tenancy with right of survivorship is it just brings us right back to Cinderella. It brings us right back to a situation where people normally don't think ill of those that they're going to marry, those that are coming into their family. They don't necessarily think that exploitation is going to take place. They're just going to give everything to the surviving spouse. But then what happens? Somebody else comes into the picture after that, might want to take control of assets, get their name on it. And this is, of course, something that I personally see all the time. Somebody will want to get remarried, somebody wants to get married, and the new wife comes in, and there's already property, there are already children there, but the new wife wants to come in and put her name on the property or his name on the property. Very, very common, and of course incredibly dangerous if you want to consider this from the perspective of the welfare of the orphans and making sure that orphans are getting their due with respect to inheritance. I wanted to see if there's any. I'm looking for the chat window to make sure there isn't anything I need to be up on. So I'm not getting any feedback or anything. So I'm not. I just want to check to see if that's doable. No, not really. Okay, never mind. We'll get there towards the end. Okay, let's talk a little bit about inheritance. And I've already kind of discussed what inheritance is. Inheritance is what it is that you leave behind. The stuff that you leave behind after you are no longer here, right? Inheritance, and a lot of people have some concerns about specific things in inheritance. Well, why does this person get this much? Why does this person not get this much? Why does this happen? Why does that happen? Why can't I do whatever it is that I want? Inheritance does not exist to solve particular social problems that you have right now. Inheritance does not exist to create some sort of recognition of something or another. The fact that you get more or less inheritance doesn't mean that you're better or worse than somebody else. That's not the purpose of inheritance. I'm going to get into the issue of gender, and I know there was a question about that earlier, and why it is that that girls might get less than less than boys, or daughters specifically get less than sons, and we can discuss that a little bit further. However, think of it this way. Somebody might ask me, well, say you have a multimillionaire son, right? I mean, you have a son, he's doing incredibly well. He's a neurosurgeon or a CEO or whatever. He's doing great. And then you have another daughter, you have a daughter, and that daughter has Down syndrome and might not be able to marry well or marry at all, and is unlikely to ever work again, is probably going to need some help. And so the question then becomes, how is it fair that a millionaire son gets more inheritance than the daughter with Down syndrome? And my answer to something like that is that inheritance does not exist to solve a problem that you yourself see right now. If you have an issue, you need to deal with it right away. If you want to give more to that daughter, and you want to be able to structure it so that it doesn't harm, the inheritance doesn't harm that daughter because of public benefits that she might be receiving, then you would be able to deal with that right now. You don't actually just push it forward to the future. Inheritance is not a way to address situations that you cannot see, because inheritance comes at a time that you cannot see, a time of which you are not aware. So inheritance is, and one of the functions that we have with the Islamic rules of inheritance is that it resolves a lot of problems before they actually come about. A lot of families have um, have issues when it comes to not being able to talk to each other anymore. A lot of families are completely broken. Cousins don't even know about each other. Brothers don't talk to each other. And if you ever were to talk, like I did, to someone who hasn't spoken to his brother in 20 years, um, you're going to, and you want to find out, well, why that is. The main reason that might be is because of some sort of inheritance dispute that happened years ago. I was in court in Los Angeles. It was several years ago, and I was there in Los Angeles on a completely different case, and inheritance disputes are resolved in probate court, even when there is a living trust, and we'll get into what that is in a moment. And when I was there, you're sitting in line and you're listening to all these cases come up ahead of you. And there was this one case that was ahead of me and my case. And I was listening to it for a while. It was a relatively lengthy argument going about 15, 20 minutes, involving 7 or 8 lawyers. And all they wanted to do was move the case to 1 week to get some paperwork. But as they were talking, it occurred to me that I actually knew this person that passed away, and I knew who he was. I went to his janazah. He's one of the more prominent families. They're one of the more prominent families within the Los Angeles area. Incredibly generous. The case was worth hundreds of millions of dollars, and the whole family was self-destructing right in front of my eyes. And it's one of these families that was incredibly tight, incredibly close-knit. All of the family members lived very, very close to each other, met with each other regularly. And then suddenly one person passed away, and everybody started suing everybody else. And it became incredibly and unbearably vicious. They ended up spending $20 million in attorney fees. And I had some clients in the lower rungs of that family. And I asked one of them, well, what happened? And his response was, the reason all of this happened was that they didn't do it based on the Islamic rules. If they had followed the Islamic rules of inheritance, if they had followed what the Quran had told them, then none of this would have happened. And so we're going to talk a little bit about the shares of inheritance in Islam. And so the way the Islamic rules work is that you take a family, it's based on whatever it is in your family tree. There are certain people who have shares of inheritance that are fixed. And fixed is a relative term. It's a question of math. Sometimes you have to actually be able to proportionally fit certain things in. But generally speaking, the surviving spouse gets between 1/2 and 1/8. So if there are no children, the husband gets 1/2 from the wife, and the wife gets 1/4 from the husband. If there are children, then the numbers decrease to 1/4 and 1/8. The parents get 1/6 each. So the father gets 1/6 and the mother get 1/6. Sometimes the father might get more if the father is like a residuary beneficiary, meaning there aren't other beneficiaries that get enough fixed shares. If there are children, the children typically get the rest, with 2 shares for the boy for every 1 share for the girl. Now, there are circumstances where other beneficiaries get inheritance. So for example, if grandfather, grandmother, uncles, aunts, cousins, these types of people, brothers certainly can get inheritance. This can vary depending on the specific family tree information that we have. And so it's not just the wife or not just the husband that gets inheritance. It is always typically going to be other family members. And so this is an incredibly important distinction from the way inheritance typically works in the United States versus how inheritance works in Islam. In the United States, by default, or at least the system is rigged that way, the surviving spouse will typically take everything. What happens when the surviving spouse takes everything? Well, you have this Cinderella situation happen, and you have a massive amount of injustice that could potentially occur. Now, even if there aren't children, you do want to make sure that other family members and people within your family's bloodline or your lineage, those types of people will also get inheritance. So it's we do have a system to make sure that it's not just the surviving spouse that gets inheritance. Okay, let's talk a little bit about the issue of girls getting more than boys. And I think one of the questions that we had to do with well, what about equal, making it equal? What if you wanted boys and girls to get equal inheritance? As almost anybody who has even a nodding familiarity with the Islamic rules of inheritance might know, is that sons get 2 shares for every 1 share that the daughter gets. And so many times people will feel, well, that doesn't sound right to me. I know it's in the Quran and everything, but I want to give more to my daughter. What do I do? How do I do that? Well, first of all, you need to understand why it is that this exists. The first reason, of course, is that it's in the Quran, and we don't necessarily need to justify why something is in there. Allah has ordained that inheritance is the way it is. However, it is important and it is instructive to look at the whole overall economic system where this type of thing comes from. Inheritance that goes to a male is not the same or the same value that the inheritance that goes to a female. And the same is true for wealth that is earned by a male versus wealth that is earned by a female. If a man has money, any money, not just inheritance, but certainly inheritance, and that's what we're talking about here today. If a man has money, that man has to use it for the benefit of females in his family. So he is supposed to make sure and take care of sisters, his wife, daughters, things like that. So he has to make sure and take care of people within his family. Now, when a woman gets money or wealth or what have you, she has no obligation that is similar. So think of it this way. Say you have a 45-year-old man, who is doing pretty well. And he has a sister who is 55 years old, 10 years older, and is impoverished. This sister, in a traditional Islamic system, can go to a court and ask the court that, hey, I need support. My brother is capable of supporting me. He's not supporting me. Make him, right? She can do that. She can go to a court and do that. Now, we're here in the United States. And in the United States, that type of a concept is ridiculous. That's not something that would ever happen in any court in the United States, as a general rule. However, well, let's move on. Let's move on as far as one of the other concerns that people might have with this specific scenario that I brought up. Okay, in an Islamic system, traditionally, a court can make a man support women in the family. There is this recognition that if a man is not fulfilling his responsibilities, then of course you can make him, and that of course gives women a property right that men do not have. And maybe that justifies this whole thing where daughters get less inheritance than sons because sons have this responsibility that is not alike with daughters. And so maybe that all makes sense and that's all wonderful, but we live here in the United States. We live here in the United States, and that same responsibility for men does not exist. And so why do we have inheritance that based on this system that does not exist? Well, first of all, there are two things. Just because that system does not exist doesn't mean that it's not ordained by Allah still. And that men still do not have, at the very least, the same moral responsibility with their wealth as Muslims. They have the same moral responsibility that they always would have had, even if a judge wouldn't make a 45-year-old man support his 55-year-old sister. Even if that were not the case, that still exists. Now, another thing is that we want to create our own system here. What are we doing when we do Islamic rules of inheritance? We're creating our own law. We're creating a law based on contract. And so what we do is we create a trust, and a trust is a contract. And part of that arrangement that we can make is that the surviving children, before they get their inheritance, and especially the surviving son or the beneficiary, can be told, you are going to support your sister if she needs it. You are going to make sure and fulfill these responsibilities. And as a condition for getting inheritance, he might have to sign something stating that you will support your sister, and that would be legally enforceable. Now, if he doesn't sign it, it just stays in trust, and he would continue to be a beneficiary, and the daughter would continue to be a beneficiary, so that the trustee will make sure and fulfill the son's obligation if the son decides not to. And this, of course, is not that different from what a Muslim judge might do under similar circumstances in an Islamic system. So if an Islamic system does not exist, what you're doing when you plan based on the Islamic rules of inheritance is that you are creating it, and you are creating it for your own family. Let's talk a little bit now about community property. Community property is the default way inheritance is distributed in, not inheritance, I take that back. Community property is the default way property is owned in California between married couples. So if you have property and you're married, and you acquired it through your skill, labor, and efforts. So skill, labor, and efforts. You're a software engineer in Silicon Valley, right? You're a software engineer in Silicon Valley. You go to work, or you work from home, or whatever it is, and you're using your skill to create wonderful products and services that come from Silicon Valley all the time, right? And you're doing that, and you're getting compensated for it. And your wife is there, and your wife is a homemaker, or maybe she works. Whatever the situation is, what happens is that 50% of what you make belongs to you, and 50% belongs to your wife. If your wife works, 50% of what she makes belongs to you, and 50% belongs to her. That is just the default system. That doesn't mean that you can't have a different system if you want it. You can decide that, hey, I have my stuff and you have your stuff, and we just have different stuff. You can do that, but you need a separate agreement to do that. Islam does not regulate the property arrangements between husband and wife. So when we talk about community property, we're not talking about giving the wife 50% as inheritance. This is what you own while you're alive and while you're healthy. So it doesn't have anything to do with inheritance, but Islam doesn't say that, oh, you're supposed to split all your property 50-50. Of course, that's not an Islamic concept, but it's actually not alien from, I mean, it's alien from Islam, but it's not prohibited. It's not prohibited in Islam to do it that way. So you could decide that you want to split your property 50-50 while you're alive, and there's actually no problem with that, in the same way that it is not prohibited for you to give your wife a Ferrari if you feel like you want to give her a Ferrari for her birthday or something like that. So you can decide what you want to do with respect to that. Now, this is a community property. You're married. You're in the state of California. You're subject to the laws of California. That's just how it works here. I'm going to talk a little bit more um, about issues that have to do specifically with the H-1B community and with immigrants, that sort of thing. Okay, so let's talk a little bit about guardianship. This comes up a lot, particularly for my clients in the Silicon Valley. And so what happens is that there are people who have children, and they're raising their children in California, the Silicon Valley, or other places in California and elsewhere. And they will feel that the best people to be named as guardians are their close family, and all of their close family live in another country. That could be in, you know, it could be in India, it could be in Egypt or Pakistan or wherever. It could be anywhere in the world. And they also recognize that that's hard to do. Will a judge allow it? Can they just do that? The way we structure it, and under California law, what judges look for is what's in the best interest of the child, and typically they're going to realize that keeping children close with their own family members, even if that family member is overseas, is going to be in the best interest of the child. So that's not a problem if you actually name guardians. Now, if you don't name guardians, they're not going to go out of their way to find relatives overseas and have your relatives stay overseas. I mean, if you don't have anybody named, the state takes over. It's basically an agency of the government that will come in and take the children, put them in foster care, you know, that sort of thing. And you want to definitely avoid that scenario if you have children. What we typically do under those circumstances is that we name guardians, like temporary guardians here in California. Typically they're going to be local. Typically they might be, so if you're in this group and you have friends in this group, you'll name somebody who's going to be a temporary guardian who's going to take care of your children up until the time that somebody can come overseas and somebody can come from overseas and take the child, get the court's permission, take the child to India or wherever that might be. And so there's going to be a process for doing that. You don't actually appoint a guardian, you nominate a guardian, and then the judge appoints the guardian. Anything that has to do with children will typically have to involve typically involve a judge in some way or another. And so we have this process where we would have a temporary guardian, and then there would be a permanent guardian, and the permanent guardian may not be able to come right away. There are all sorts of risks, of course, with international issues like we have right now, where there's a global pandemic that's going on that's causing air travel to just not take place. Consulates and embassies are closed, and so visas are going to be difficult, and that's happened multiple times, at least throughout my career, where people have had trouble coming from one country or another to the United States, and so it could be difficult, and it could take some time, but you do want to make sure that your instructions are there, they exist, and the government will know what's supposed to happen. Now, we typically do these guardianship instructions in something called a last will and testament. A last will and testament is instructions on what is supposed to happen after you pass away. A lot of what we do when we do estate planning is pieces of paper with stuff written on it. It's not necessarily important to focus too much on what this document is called or what that document is called. Of course, it's necessary to know what they are, of course, when you're doing them. But the main thing you need to be concerned about is peace of mind. You need to make sure that you're doing right by the people that you love and that you care about, and that guardianship is done appropriately, that inheritance is done properly, that you have people in place to take care of your affairs. There's another document that we do. It's called a living trust, and a living trust is a method of owning property. So it's a contract, and that's the main way we do Islamic inheritance here in California, or actually anywhere. Inheritance is typically distributed through a trust to avoid something referred to as probate. And probate occurs when you need a dead person's signature to transfer property from one person to another. When you do that, you have a probate. And so what we do is we avoid judicial supervision completely by privately administering the estate. And so you name people, you name a contract, the trust is a contract between three different kinds of people. One is the grantor. The grantor is the person who creates this trust in the first place. And the second person is the trustee. So the grantor nominates or appoints a trustee. The trustee manages the property for the third person in this arrangement, and that is the beneficiary. The third person is the beneficiary, and the beneficiary is the whole reason this arrangement exists. So the grantor appoints a trustee to take care of the beneficiary. Now, while you're alive and healthy, you would be all three of those things. You would be the grantor, you would be the trustee, and you would be the beneficiary. You're going to manage everything the same way you would if you didn't have the trust. But then what happens is that you appoint successors. You appoint somebody who would be the successor trustee, and then you would appoint successor beneficiaries. Now let's talk a little bit about your status. The amorphous, I suppose you some of you might be, some of you have, I mean, many of you I'm sure have different immigration statuses. One thing to understand about U.S. residency is that there are different definitions in the federal government. Now, from the perspective of California, you're here in California. California doesn't care what you are, where you came from. If you're a property owner here, you're going to be subject to the laws of California. But then there are these other rules that have to do with your immigration status in the United States, as well as tax treatment of your estate. There is a exclusion amount. First of all, you need to understand if you are a U.S. person or you're a foreign person. Then that means if you are a resident of the United States, or if you are not a resident of the United States. Now, when we talk about who is a resident of the United States, the first thing, especially if you're like an H-1B or you're a green card holder or something like that, you think, okay, well, a resident means somebody who has a green card, somebody who the immigration authorities have said, okay, you're a resident, you're a permanent resident of the United States, you are a U.S. person, you're either a resident, you're a U.S. citizen, something like that. That is a resident. Well, for our purposes in estate planning, that's actually wrong. There are other provisions, and so there's the U.S. tax code. Under the U.S. tax code, there are different definitions of resident of the United States. Now we have a system known as the U.S. The federal income tax system, and under income tax law, you have a different definition of resident that is completely different from the immigration definition of resident. So long as you live here, you're a resident, and then there's a definition in terms of how many days and how many days you live here within the 3-year period. That's under the income tax rule. Now there's also within the tax code, there's also the estate and gift tax system. Now, the estate and gift tax system is also part of the federal tax system, but it has different definitions for some of the same things. And so you can be a resident under one definition, but not be a resident under another definition, and be a resident or not under the immigration system. So these are three separate systems that don't necessarily talk to each other. And so you might be a resident, and for the estate and gift tax system, being a resident or not is actually a lot more amorphous. There isn't a system in place or there isn't a very good definition in place. A lot of times things actually just go to court. It has to do with what your intentionality might have been. If you lived here and you intended to stay here and then you passed away, how are they going to tax you? And it makes a massive amount of difference. So there is an exemption if you're a U.S. person from the estate tax of $11.4 million. It's gone up a little bit recently. It's roughly about $11.4 million per person. So if you're two people, you're a married couple, I mean, it's well over 20, I mean, it's over $22 million, right? As far as the exemption amount goes. So what that means is that if you have that much money, the federal government isn't, if you have less than that much money, the federal government isn't going to tax you at the federal estate tax rate, which is 40%. So 40% of whatever you have above the exemption amount is subject to the federal estate tax. If you're not a U.S. person, it's like $60,000. If you have more than $60,000, then you are subject to the federal estate tax. And so there's a bunch of rules about how you should handle your assets. If you're not a U.S. person and you maybe just come here once in a while, or you work out of the U.S., but you also live in another place, then you can actually have significantly more in U.S. assets, so long as you structure it properly. But if you are structuring it just as you're in your own name and you're not a U.S. person, you can be hit with a massive, I mean, absolutely massive estate tax. And so you would want to avoid that if at all possible. So one of the things you need to be able to understand is, well, you're probably pretty clear about what your status is as a resident or non-resident of the United States. But you can be a non-resident, like you can be somebody who's only here temporarily, not temporarily meaning a few years or a decade or more, or whatever the case may be. And you might be considered a resident for certain purposes, meaning income tax, but you might be a non-resident for the estate tax system, and you might be a non-resident, in the immigration system, or things can be switched around in other ways as well. So part of what we need to do when we consider estate planning is, well, what is your status? What's your exemption amount? And are you going to be hit with the estate tax or not? Some of the things that we need to be able to consider. Okay, this comes into the questions that we've gotten, and I know that there are some other questions that I'll address as well. But what do we do with respect to signing of documents? And so these days, this has actually been a major concern of mine, because I do get clients. I'm getting quite a few clients these days who want to be able to address estate planning issues, but then we need to focus on, well, how do we actually get the work done? How do we get people to complete their documents? And so under California law, you actually need to have two witnesses who are present at the same time, and they need to actually either witness the signing or witness you telling them that you signed a document that they're signing on as witnesses. So you can do this with social distancing. The same thing with a notary. You can actually do notary safely with social distancing. And some people are very, very concerned about seeing or talking to anybody. And that's unfortunately a challenge, especially some of my older clients. But we need to actually work through that. One of the things that we can also do is remote notarization. Now, this is not allowed in California, meaning of California notaries. It is allowed in California of out-of-state notaries. So there are certain out-of-state notaries that we can actually use that will just notarize everything using a webcam. So just like I would meet with clients virtually, I'm meeting with you virtually. We can actually do notarizations virtually. Unfortunately, we cannot do witnessing. We can't do witnessing virtually. One of the things I will suggest to some people is that, if you know a married couple in your neighborhood, just have them or their friends that they live reasonably close by. They can just come by. You can just tell them that you signed a document, and go to have them open it up themselves without you actually having to walk to them. We'll have it all tabbed up where you can say, there's a tab and there's a sticker, sign there, sign there. We'll just say, tell them that, okay, you signed the document, and then you should be able to do it. You should be able to do it just fine. The whole idea here is to just make sure that your affairs are in order and that you have peace of mind. And the fact that you have this emergency going on, and one of the main reasons that people are much more attuned to their own mortality because of this emergency. You don't want the emergency to actually cause you to not be able to take care of your own affairs. And so I think that there is a way to address these types of things. let me actually address some of the other questions that that I had. Um, now, why we need to consider a will and living trust? Oh, can I do a California living trust which is fully Sharia compliant? Yes, absolutely. You can do a California living trust that is fully compliant with the Sharia. Remember, one of the things I said earlier in this presentation is that we have free alienation of property. Free alienation of property. I can do whatever I want with my wealth, and certainly you can if you can do that. You do have religious freedom here in California. You can make sure that your wealth passes on based on your values. And yeah, we can do that. Now, a few things about this, though, is that you don't want to do a plan based on a will. You want to do it based on a living trust. Now, I mentioned before you're going to do a will. I'm not actually saying that you're not going to do a will, but the main crux of your estate plan is going to be in a living trust. It's going to be privately administered. And the reason for that is you don't want judicial supervision. You don't want a judge deciding on things, because a judge, not because they don't like Muslims or any of that stuff, it has nothing to do with that. They might not be able to, because of certain statutes, actually implement your estate plan based on Islam under a range of circumstances that don't exist in a living trust, but they do exist in a last will and testament. So we wouldn't do that. Aside from that, a last will and testament based plan is significantly more expensive in California because of probate. Okay, so why we need to consider will and living trust that is Sharia compliant? Of course, it's fard. Islamic inheritance is fard. The Quran is actually quite clear on that. That you know, if you obey Allah, you go to Jannah. If you don't, you're not so lucky. It's actually very, very strong language. You want to do justice. Your last parting shot on this planet is not to do an injustice to the very people that you claim to love. You don't want to be in that situation. You want to do right by the people that you love and care about. Okay, so let's see. Living trust done through less expensive online sites like LegalZoom is valid. Any pitfalls? Okay, so I'm going to say this about that about anything that you're doing online or any form filling type of a website or anything like that. If it gives you peace of mind, then do it, right? If you want to do like a will with your hand and write it down, if that gives you peace of mind that you're doing right by the people that you care about, then do that. If you're the kind of person that will go to a lawyer because you think that that's responsible, or that's you want to be able to be acquainted with the issues, or you're going to make sure that you're doing things, you're asking questions, you're getting good answers, you're getting advice, and you're making sure that you have a plan that is appropriate for your family. Yes, it's going to cost significantly more, but does it give you peace of mind? If it doesn't, then obviously then then even that would not make any sense, right? So you do want to do what is best for your family. One of the things that I always tell my clients when they meet with me, I don't tell everybody this, but in general, I mean, the thing that I might point out is that nobody ever gets richer or better looking coming and talking to me. That's not the purpose behind estate planning. The purpose is to take care of your loved ones. And if taking care of your loved ones means doing it for 15 minutes online and filling out some blanks and done, then and you're happy with that, you think, okay, it's good. I'm taking care of everything. Then you've taken care of everything. I would say that. There are, of course, pitfalls in estate planning. There's a lot of litigation that goes on every single year. The courts are quite busy and a lot of the reason for that is planning that was not especially well thought out. But that could happen with or without a lawyer. I mean, just because you have a lawyer doesn't mean that your plan is going to be necessarily great, right? If you're going to have a lawyer, even an experienced lawyer, you need to be engaged in the process. You need to care about what it is that you're doing. You can't just, okay, here, just take care of it, do it for me, and that would be it. There's a process. It's a relatively lengthy process in the sense that, it's not just taking 10 minutes or 15 minutes online and getting it done. It's just a chore that you need to take care of. It's significantly more consequential than that. Okay, so let's see, what is your advice on distribution of percentage for kids, multiple kids, if one wants to do it equally? I think I already answered that. Yeah, you could actually, no, I didn't. I talked a little bit about the issues. If you want to do it equally, you really can't. I mean, the Quran actually doesn't allow for that. Inheritance is the way it is. It's a minimum and maximum, at least relative to each other. You do have the ability, and I did not discuss this yet, which is the wasiyah. You have the ability to give up to 1/3 of your estate to a beneficial purpose. That does not include your children. So a waris cannot, or a warasa cannot get the wasiyah, right? They can't actually benefit from the wasiyah, which is up to 1/3. You can give to charity or other purposes. You can give to daughters during your lifetime. So if you want to give it to them now, you can. And that's perfectly fine and acceptable. And there are a lot of ways to do that. People can actually give real estate or business or portions of businesses that they control, things like that. They can give that to daughters, and they can give it during their lifetime, and that's fine. Now, that doesn't actually mean that you're going to have equal inheritance. Inheritance is going to be exactly the same. Remember, the definition of inheritance is the stuff that you can't take with you. And once you're gone, whatever's left over, that's inheritance. Now, if you're giving it during your lifetime, that is not inheritance, because you're giving it now. And once you've given it, it's gone. You can't get it back. If you're going to give it to somebody and say, I can take it back anytime I want, well, you haven't given anything. So, you can't do anything as far as giving equal inheritance. However, you can do it. You can give more during your lifetime. Now, will that ultimately mean that inheritance is going to be equal? We don't know. We don't know when you're going to die. We don't know how much wealth you're going to have. We don't know who's going to be rich or poor. We don't know any of this stuff, right? So just because you're giving your daughter stuff right now doesn't mean that the inheritance is going to be equalized. There just isn't any way of knowing or predicting that you're going to end up giving equal inheritance. You can totally give a lot to your daughters. You can be very, very generous with your daughters during your lifetime, but you don't necessarily know what the inheritance situation is going to be looking like at that particular moment. Yeah, you can, how to transfer a right of custody to someone of my choice right after death. That's guardianship. And so you do that in a last will and testament. What you're going to need to do is, especially if you don't have close family here in the United States, you want to be able to let somebody know, like your friend. And this is one of the problems, that your friend is not intuitively going to know necessarily that he or she is supposed to spring into action if he were to die, right? So you're going to have a last will and testament, and you're going to tell your friend, look, I am here. I'm here in this foreign country, and I don't have all my loved ones are in another country. They're in India. And what I want to do is make sure that those kids, my kids, get there so they can stay with their uncles and aunts and grandparents or whatever. And I want you to make sure that happens. I want you to be the person who, if my kids are at school and I can't pick them up, I want you to be the person that would pick them up. I want you to be the person that will take care of them, that will call my parents and let them know, hey, this is what happened. I'm taking care of the kids. If you want them, we can make these arrangements. You need to actually let somebody know. You have to be a little bit more proactive about this type of a situation, because friends, your friends socially, but you don't necessarily think of your friends as people who are going to be taking care of your kids. And now, when you're in this country, when you're in this environment, you need to be able to think of your friends as people who, at least on a temporary basis, are going to be trustworthy enough to take care of your kids if there was some sort of an emergency where you're not able to take care of them. So, so you do need to make those arrangements now. Actually, is it possible to use an organization like KMCA or MCA as guardians of kids? No, you can't have. You're going to need a person. You need to actually have a person. You need to actually think in terms of people who are going to be guardians. Institutions are not going to be guardians unless, of course, it's a government institution. But no, generally we don't have nonprofit organizations as guardians of your children, and any guardianship situation that you have is going to have to be temporarily. Can we do this remotely? Do we need to notarize documents? Yes, absolutely. You can do this remotely. I've been doing work in Silicon Valley remotely for well over a decade. I have many clients in the Silicon Valley that I've actually never met in person. It's very, very common that we would do this. Let's see. Can I find let's see, like a legal service, like one of those legal services that are done by the employers. And do I accept clients from the Bay Area? I think I accept. I think there's just one. I think CMC or something. I forget the name of that. Generally, I don't go on to legal plans or anything like that. They will. Most of them will. Actually, I think virtually all of them will allow for out of network uh, out of network attorneys. But you're normally not going to see um, estate planning specialists. Be part of that. It's going to be mostly generalists that are part of those types of things. And yeah, it's generally not worth it for attorneys to be part of that, or I guess most attorneys to be part of that type of thing. In a trust document, should we assign the custodian as a U.S. citizen? Can I assign friends with an H-1 visa? You can absolutely assign friends with an H-1 visa. That's not a problem. California is not going to require that a guardian, especially a temporary guardian, needs to be a citizen of the United States. That might be a consideration in what is the best interest of the child. But most of your friends who are H1 have H1 visas. They're basically, I mean, there wouldn't be a problem. Let's just put it that way. What would need to be considered in identifying a custodian? Now, when we say custodian, I am assuming a guardian for minor children, and the types of things that you would want to be able to identify. First of all, if it's your family that you trust implicitly, of course, that would be wonderful. They often share your own values. They might be overseas, but that's fine. One thing you definitely should consider in any guardian for a minor child is when I say, of course, they have your values. Think of it this way: if your child were to ask you, look, I want to quit school and I want $50,000 to start a rock band. The answer would be the same for you and for the person that you're appointing, right? That they basically share the same values. And you want to keep up with this too, because things change. I mean, for people switch out friends every few years. I read once that we replace about 50% of our friends every 7 years. And so, there might be people over time, and I've seen this many times with my clients, is that they name people, and a few years later, those people don't really have much meaning in their lives. And so you do want to actually look at this every few years and make sure that, yeah, these are the same people that would be appropriate for this type of a role. Okay, Jazakallah khair. This has been a new experience for me. If there are any questions, any additional questions, then I would be then I'd be happy to answer them.
Jazakallah khair. Let's see if we have any other questions. There was one question about the approximate cost of doing this in California, maybe.
Yeah, of course. So I charge a minimum of $2,500, and for married couples, it's $500 more. So for married couples, it's about $3,000. And that's the minimum cost, and then it varies widely depending on the design of the plan. But yeah, that includes like a deed to the house, a living trust, power of attorney, the wills, healthcare documents, property agreement. It includes just a large number of documents, or several documents, I should say, that is generally included in the estate
plan. Right. So we have another question. Is the residency test for federal income tax and the estate tax the same? Like I'm an H1B and I work and live and work here. So will I be the estate tax on my death? Like if I have less than $1 million or $11 million, what you were mentioning earlier?
So that's a question of that's a pretty vague it's a pretty vague definition under the federal estate tax law. Generally speaking, you are a U.S. person if they can evidence that you intended to just stay here. As long as you intend, so they would actually have to find your intent. If you're one of these people who are like, I'm just going to be here for a few years, make some money, and then go back home. If you're one of those people, then and the government sees evidence that you are one of those people, they might actually just say, well, he wasn't really a U.S. person. But if they do, if you actually do have some evidence that you've established roots here, you're continuing to live here, maybe you're going to get a green card someday, something like that, then they would establish you as a U.S. person. In the income tax rules, it's much more it's much more clear cut. If you've just been here, and if you basically just you go back to India just for visits and you basically live here, then you're a U.S. person under the income tax rules.
Okay. Another one was like, do we need a living trust if we don't have a residential property and have just a bank account and cars? Like, or can we do the living trust later or modify it when we acquire a residential property later?
Yeah. So the way we handle that kind of question is, well, you do want wills and things like that, but as far as a living trust goes, a living trust is just a mechanism for distributing your property after death. That's very similar to what we would do in a will. The main standard that people sometimes use is whether or not there's going to be a probate, and I think that's wrong. That's the wrong way to look at it. You should have a living trust if you have a sufficient amount of property in the United States, regardless of whether or not you actually come up to the limit. So the limit for probate, meaning if you have more than a certain amount, then you create a probate in California. And that is this year $166,000. So if you have assets in excess of $166,000, you are in the zone of actually having a probate, which means roughly, probate is the cost of statute is in statute, and so it's about roughly 5% of the gross value of your estate. So say you have a house and you have $1 million house and it's worth, and you have about an $800,000 mortgage on that house. The cost of a probate would be roughly $50,000. So don't hold me to those numbers. It varies depending on a wide range of factors, but a probate could be quite expensive. But a probate isn't necessarily the only reason to plan based on a living trust. There are other reasons, and there are other reasons to plan, but administration of an estate is actually quite easy if you have just a bank account, for example. If you only have a small bank account, or if you have relatively few assets, then administration of the estate in California is actually quite easy if you have a will or something like that. But otherwise, I would frequently recommend a living trust. And yes, you can modify your living trust over time depending on your needs. Depending, if you get a residence or something like that, you might actually have additional factors. One of the things that you actually do want to consider with a house is who's going to live, how are you going to handle the house if there's a surviving spouse, right? So if there's a surviving spouse, do you want your wife to continue to live in the house or your husband to continue to live in the house? And what does that actually mean for the children? You want to be able to continue to give the surviving spouse a place to live in dignity through his or her old age, while at the same time not denying the children their right to inheritance. And so those are important considerations that exist when you have a house, not just the issue of, say, probate.
Okay.
Mm-hmm.
So again, another question about the cost. Like, can the legal insurance cover the cost which you mentioned?
Yeah. So they might cover part of it. You might want to go out of network for that. I don't normally go with legal insurance. I think KMCA, or I think the organization is KMCA. I think that's the only one. I think they have a number of tech companies that are part of that. So I think I am part of that. Like authorized through them. You can go through them on that. But otherwise, I'm not. Like there's some of the other insurance ones. I think they offer like a discount or something like that. Or not a discount, but I think they offer like a reduced cost. So it's still a cost, but I don't think I'm on any of the ones that will just offer it for free. To learn more about it, I should have pointed this out, is go to my website, islamicinheritance.com, and I also have a guide on a resource guide on Islamic inheritance. You can just text inheritance to 44222, and you can learn more about some of the articles that I've written on it. But any other questions?
There was a question about name change. Like, if somebody plan to do a name change, do you recommend doing the name change first and then do the will, or do the will and living trust now and modify it later?
I don't think that I don't think that matters very much. Normally, when we do living trust wills, we do AKAs anyway. So a lot of people are known by multiple names, and so I don't think we need to do a legal name change in order to do that. In the living trust, we actually just do recognize that okay, this person is known as this name, but has also been known as this other name, and that's relatively common. So you use alternatives. Just because you do a name change doesn't mean your old name is no longer relevant. It still continues to be relevant.
Okay. And I think I have one more question about home ownership through the cooperative society, like the housing societies.
Right.
So, is there anything specific we need to do? We need to do with the trust if it is through housing?
Not really. I mean, whatever your ownership interest is with housing would just be owned by the trust. I mean, it's a little bit of a different model, housing, but you can. It's still possible. We've had several clients using housing in the past.
And also, like, just having a recorded trust, will it completely avoid a probate court process?
The mere fact that you have a trust doesn't necessarily avoid probate. The main thing you need to be able to do is register assets in the name of the trust. So normally what we do is we put the house in the name of the trust, and the other assets would be in the name of the trust as well. Sometimes people might get a business entity, or they might get a house that's not in the name of the trust. As the years go on, one of the more common things that happens is people will refinance their house. Because they might get a better deal with some other company, and so they're going to refinance their house. And what happens is that if it's done through Fannie Mae or Freddie Mac, Fannie Mae or Freddie Mac they don't like it they don't want to refinance houses that are in a trust, which is not a problem. What happens is that you take it out of the trust while the refinancing is happening, and then you put it right back in when the refinancing is done. So when the deal is done, you just put it right back in. Sometimes, actually frequently, the title company or somebody will recognize, oh, it's in a trust. Do you want to put it back in? And you'll be like, yeah, sure, put it right back in. And in the same suite of documents that you have to sign and notarize, there'll be a deed taking it out, and there'll be the deed taking it back in, and it's just a seamless process. Other times they'll just forget to do it, and it'll be taken out, and then that might cause a probate. And so you do want to make sure that not only are the assets properly registered now, but they're registered as well in the future.
So for if we have property in India, like for US born kids, do we need to handle it in India separately, or we want to handle it here?
For property in India, you do want to handle it in India. So yeah, you do want an Indian lawyer, and you want to be able to manage that in India. I should say that if there's an estate tax issue, or there's any type of taxation issue with Indian property, if you are a U.S. person, under certain circumstances, particularly when you become a green card holder, but if you become a U.S. person under income tax law, and under U.S. estate tax law, then you might be subject to, this particularly happens once you become a citizen, you might be subject to income tax on all of your worldwide income, and the estate tax on all of your estate globally. If you're not in that zone, then you don't necessarily need to worry too much about it. If it's not that much, but income tax you may have to worry about under certain circumstances.
Okay. Is it better to do a guardianship and living trust together, or can we just do a guardianship right now and living trust later when we acquire a property?
So I actually have a form, I believe, if you were to text that on doing guardianship, so you can just do guardianship, a separate document in California. You don't necessarily need to do it in a will. You can just write it down, and if there's one thing that's valuable to you, especially if you're not going to go to a lawyer right away, is that you could take care of your guardianship yourself, and then talk to your friend here, especially if you don't have family members here, and let them know that, okay, you need to be my successor guardian. That's a relatively easy process that you can do, and you can do that yourself. Of course, I would always, as far as the estate planning, inheritance, and just doing it, doing all of that stuff is vitally important. But if you just wanted to take care of the guardianship issue, you can do that without doing a living trust. I would recommend doing everything together if you can. But if you can't, or if there's something else going on, you can take care of the guardianship at the very least. Yes.
Now we are slightly over time, so I think we answered almost all the questions.
Wonderful.
So I just want to invite Brother Surjaz to conclude with a dua.
Jazakallah khair, Brother Nasid. On behalf of Assalamu alaikum wa rahmatullahi wa barakatuh. On behalf of KMCA, I would like to thank for joining us this afternoon and educating us about the Islamic Will and Living Trust. Also wanted to thank Brother Nasid for organizing this and everyone for participating. Hope this is all of you. So we'll have a small dua and then conclude the session. Alhamdulillah Rabbil Alameen. Allahumma salli ala Sayyidina Muhammad wa ala ali Sayyidina Muhammad. Allahumma inni as'aluka al-afwa wal-afiya fi dunya wal-akhirah. Allahumma inni as'aluka al-afwa wal-afiya fi dini wa dunya wa ahli wa mali. Allahumma astur awrati wa amin rawati. Allahumma bayni yadayya wa min khalfi wa an yamini wa an shimali. ومن فوقي وأعوذ بعظمتك أن أغتال من تحتي. بسم الله الذي لا يضر مع اسمه شيء في الأرض ولا في السماء وهو السميع العليم. اللهم عافني في بدني، اللهم عافني في بصري، لا إله إلا أنت. اللهم إني أعوذ بك من الكفر والفقر، اللهم إني أعوذ بك من عذاب القبر، لا إله إلا أنت. ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار. ربنا تقبل منا إنك أنت السميع العليم وتب علينا إنك أنت التواب الرحيم. آمين برحمتك يا أرحم الراحمين. جزاك الله خيرا again. السلام عليكم.
السلام.
Assalamu alaikum. Jazakallah khair. It was a pleasure.